Says we're live. I always like to check it on the Facebook to make sure before I bring my guest up and we start talking about important stuff. Yep, sounds pretty good. This is of by and for the people, but constitutional deep dives. Excuse me. It's with Eric Buchanan. We'll let him tell you what he does and who he is. But to spin off of our Monday conversations yesterday, the weather got in the way. So if you notice there wasn't one there, it's because we had severe weather moving through. Some of us had internet. Some of us may have been stuck on the side of the road. You never know. But these conversations are minus the narrative and the political narrative of most of the time. We might give our opinion every now and then. It's stuff we probably should have learned or might have learned and forgotten. But these are the deep dives. We're going to go line by line through the Constitution, the Bill of Rights, the Declaration of Independence eventually, all those things. Let me take that off the screen. And let me bring Eric Buchanan up. 3, 2, 1. Eric, we're going to be talking about Article 1, Section 8, Clause 4 today. And, sir, you said yesterday you were going to make bankruptcy fun, entertaining, sexy, intriguing, mysterious.
Yeah, I think this is going to be an exciting day. So we're going to talk a little bit about the thinking process of the founding fathers, a little bit about the great triumvirate, and then we're going to talk about how an exotic dancer changed the role of the federal courts and the bankruptcy courts in American history, not once, but in two different important Supreme Court cases.
All right. Well, I'm in, dude. I'm all in. Let's tell everybody who you are and what you do, and then let's jump straight into this bad boy.
Yep. So, hi, everybody. My name is Eric Buchanan. I'm a disability insurance attorney in Chattanooga, Tennessee. First commercial for my firm. We at Eric Buchanan and Associates help people all over the United States who have long-term disability or disability insurance policies and don't like the answers they're getting from the insurance company. If an insurance company is supposed to be paying benefits under an LTD or disability insurance plan, we will fight the insurance company for you and we will help get you the benefits you deserve. We will do that in any state around the United States. We work with local counsel in other states where we need to, where we're not licensed. So we do that nationally. We'll do that whether it's Hartford, Unum, MetLife, Aetna, Reliance Standard, Cigna, Liberty, any of those companies. I could go on and on. We've been doing this now for over 20 years since I started my own firm, and I was doing this work even before that. We also help people with health insurance, life insurance, and long-term care policies. We have a team of attorneys and great staff people that can help. We can be found on the World Wide Web at buchanandisability.com or toll free 877-634-2506. Very briefly about me, I was a history major, especially paid attention to U.S. history. Then I served in the U.S. Navy for 5 years as a P-3 naval aviator, flying sub-hunting airplanes around the North Atlantic mostly and some other places. Chasing Russian submarines at the end of the Cold War was one of the more exciting things I got to do. And then I went to law school at W&L, and I especially paid attention to constitutional law. I was even the research assistant for my constitutional law professor.
There we go. We're going to be talking about Article 1, Section 8, Clause 4, bankruptcy. Eric Buchanan, we normally start off with you reading this to us. Read it to us, and then let's start this sexy, intriguing journey.
It's gonna. I promise it's gonna. I promise it's gonna get. It's gonna get there. Just hang on. Hang on. Put your seatbelt on, Clint.
I'm all in, dude. You had me at exotic dancers and government. Let's go.
All right. So Article 1, Section 8, Clause 4. Remember that Article 1 covers what the legislature can do in the United States at the federal government level, the Senate and the House of Representatives. All of their powers, the responsibilities, the requirements to be a senator or a representative, all that stuff is found in Article 1. It breaks it all down. Article 1, Section 8 gives a list of about 18 specific line items, but some of those line items cover more than one thing. It's about 26 different powers that the federal government has. If it's not on that list, it's not a power the federal government has. The federal government does not have all the power that a government could have generally under the power of nations under the rule of law. The states have the power generally that any nation could have, and that's limited by the Bill of Rights and what the Constitution says about what the states can't do. But the federal government is even more limited. It can't do something if it's not on this list in Article 1, Section 8, or otherwise found in one of the amendments or somewhere else in the Constitution.
And one of the things I want to add before you read it to us is I have found by listening to you and these conversations is some of the biggest problems we've had is when the Supreme Court or politicians try to reach outside of that and interpret the Constitution in such a way, instead of interpreting it the way it was meant, they interpret it the way they want it so they can get these powers. And we've seen this ebb and flow of overreach, and then we see decisions where they're clawing it back, and then that creates the division because we trust our government, and we trust our Supreme Court, and when they get things kind of wrong, it causes this. Oh, this is a new juncture in history, and then we try to claw it back. Everybody's like, "Wait a minute, what?" We just seen this ebb and flow of push pull.
Yeah, absolutely. The idea of how much does the federal government be able to do, whether we follow the strict wording of the Constitution, how do we interpret it? This has been a lot of questions that have been asked in the 20th century now and into the 21st century. How much power should the federal government have? Uh, Without getting too far off topic, I'll just kind of say generally the trend in the 20th century was to quit paying attention to these limits in the Constitution. The federal government just gained more and more power.
Yeah.
There has been a trend back the other way where the Supreme Court in a series of cases has said, wait a minute, let's see what the Constitution actually says about this. What did the founding fathers intend about this? And politically that might be playing part of it. Otherwise, it also there's trends in American history where these things ebb and flow. And so I think it's just important to understand what are the arguments that both sides are making, and let's understand what the Constitution actually says and what the founding fathers say about it so we can understand these things. So here we go.
All right,
Article
let's
1,
do it, man.
Section 8, Clause 4, the Congress shall have the power to establish uniform laws on the subject of bankruptcies throughout the United States is the second half of that clause. The first half of that clause we talked about last time was naturalization, immigration, the rules about what does it take to become a U.S. citizen and to get into the United States. Today, it's about the rules of bankruptcy. Now, before you go to sleep, I know bankruptcy is not the most exciting topic, but I promise that before we are done today, we're going to talk about some very salacious stuff. We're going to talk about big money and big boobies. I promise. We're going to be into all that
That
before
word is not in the Constitution.
that word is not in
I'm
the
no
Constitution, but
constitutional scholar,
but it,
sir.
it's going to come up in some of the stories today.
Okay,
But
let's hear
but before we
it.
get there, so let's get a little background. So first of all, what is bankruptcy? This was around even before the United States, and the idea is originally in British law and in commercial law, a business that could not pay its debts could go to court and have some of its debts erased or some of its debts spread out over time so that the people the business owed money to, the creditors, would either all get paid a little or would get paid evenly, and the business might still be allowed to operate in order to pay people off over time, or if it couldn't operate anymore, that the assets were divided equally among the creditors or fairly among the creditors or in a certain order among the creditors. And those are called bankruptcy laws. Now, originally, the British common law had the rule that it was only for businesses and merchants. It couldn't apply to private individuals. Private individuals fell under something called insolvency laws. And basically, that was all right, how much of your money do we take from you? And then once you run out, we put you in debtor's prison. And then there's certain rules when it comes to debtor's prison where you can get out if you're getting out to go work to earn money to pay off your debts.
Right. Yeah.
Otherwise, you don't pay your debts. Back in the old days, you go to prison for not paying your debts.
Right.
So the modern trend, of course, has been to allow both businesses and individuals to be able to discharge their debts in bankruptcy and to do it in a way that's most fair to the creditors. And the rules have a whole lot to do with who gets paid first and who gets paid second and who gets paid if there's any money left over after that and all that kind of stuff. But
Yeah.
before we get into that modern trend, just understand that originally one of the disputes was, does this bankruptcy as written in the Constitution only apply to merchants or does it apply to individuals? So what were the founding fathers thinking when they put it in here? Well, one of the things they put in here was that one of what they were thinking about was if the United States is going to compete on a global stage, we need to be a country with basically a system of a rule of law that allows for commercial enterprise, for businesses to have some assurance that they're going to get paid on their debts, that contracts are going to be enforced, and they're not going to be treated differently from state to state. That also started to be one of the things that was concerning to the founding fathers. And so if you looked around the world, who was doing really well financially? It was the Dutch, it was the British, it was the French until the French Revolution. And then there's a whole, we could talk about a whole different history there someday. But there were these empires and there were these countries that were switching over from being colonial powers that just made money like the Spanish did by going and stealing gold and mining for gold and using slave labor to make stuff, to actually the Dutch trading a whole lot and the British starting to manufacture stuff a whole lot. Well, what makes the business world go around? Part of it is the ability to borrow money in order to invest it and then to grow your business, to buy a ship, to build a factory, whatever it is.
Buy product and house them somewhere. Yeah.
Exactly. And so if the United States is starting to eventually going to compete on the world stage, we need to have some way of dealing with debtor creditor laws. And that was basically the idea of bankruptcy. Another problem became that a lot of the states, the majority of people were still farmers and living out in the country, and they started passing state laws during the revolution and right after the revolution that made it harder for the big city banks to collect on their debts. And then what ended up happening though is they would stop loaning money. So there was this idea that the farmers would vote a law that basically says it's easy for us to say we're not going to pay something and make it harder for an out of state bank or out of state creditor to collect money in our state. The problem then became, though, then the farmers couldn't borrow any money. We didn't have very much of a cash economy. There wasn't much cash in circulation because we had these very farmer friendly get out of jail free card type laws. And so the federal government said, wait a minute, we need to step in here. The founding fathers said we need to step in here. If we put in a uniform rule, then we can also stop these states from just giving people get out of jail free cards. But at the same time, we can limit the power of the creditors, that they just can't like throw somebody in debtor's prison. So those are the kind of fights that were going on.
Okay.
James Madison, I love reading from the Federalist Papers just to give a flavor of what the people were saying about this. James Madison said in Federalist number 42, the power of establishing uniform laws of bankruptcy is so intimately connected with the regulation of commerce and will prevent so many frauds where the parties or their property may lie or be removed into different states that the expediency of it, i.e., Congress's power to regulate bankruptcy, seems not likely to be drawn into question. The founding fathers basically agreed that this is one of those things that was going to make us a nation and not 13 separate nations. That having uniform bankruptcy laws would allow us to operate as one big country and deal on the international stage and deal fairly with each other. So it really
Okay.
wasn't argued a whole lot about during the Constitutional Convention. It got added in there. All right, very quickly, here's a quick history of how the bankruptcy laws exist in the United States. The federal government didn't pass the first bankruptcy law for about 10 years. They passed it in 1800, but that went away in 1803. There was no federal bankruptcy law again until 1841, and then that only lasted for 2 years and got repealed. And the next one didn't get in place until 1867 after the Civil War. So basically, except for a 5-6 year window or 2-3 year windows, basically, a
It was
3 year
just
window
left
and
up to the states.
it was left up to the states until
Yeah.
after the Civil War. And so the one after the Civil War only lasted from 1867 to 1878. And that's basically the same time period as Reconstruction. And
Mm.
then it went away again. And then it finally came back in 1898, and that's sort of the one we have now. Although the real system we have now was really redone and reestablished in 1978.
Okay.
So what did the 1978 law do? Let's just talk about a couple key things. There's chapter 7, chapter 11, and chapter 13. Chapter 7 is an either a individual or a business that is so broke that they're just going to shut down, or the creditor is just not going to have the individual is just going to have to sell all his stuff that's not exempt property,
Basically
like
liquidate what he has or
liquidate what
she
they
has.
have,
Yeah.
except for
Pay
like
off.
their clothes and
Yeah.
maybe their house is protected, but everything else, all their real assets, they have to sell off. The business has to sell them all off, and the business is shut down, or the individual gets rid of basically all their assets, but all their debts are discharged.
Hmm.
And there's very complicated rules that I took 2 semesters of this stuff in law school on bankruptcy, and I'm nowhere near an expert on it, even though I took 2 semesters of bankruptcy and got good grades in it. It's so complicated. It would be, we could do a whole series of podcasts just on bankruptcy law. But the essence of it is that they want to make sure that who gets paid first? Well, whoever's helping to resolve the bankruptcy gets paid first, the lawyers and the creditors who loan money during the bankruptcy to get people through it. Or then who as a secured asset, like when you buy a car, the bank takes a note on your car so they
Hmm.
can get the car back, or your house has a mortgage on it. And then who gets paid last? Well, general unsecured creditors. Who's that? Like your credit card companies. or your mom that you borrowed money from, but she didn't take a note, she didn't take any kind of a lien on anything when she did that. So that's how complicated it is. So Chapter 7 basically means your business is shut down, or
Yeah.
you just have to sell almost everything. Chapter 11 is when a business is going to keep operating and it gets to rearrange its debts and pay them out over time.
That's the one most, just so people understand, in my world, that's the one when you see that this business is filed for bankruptcy, Chapter 11. That's usually the one that's used the most when businesses struggle.
And they can keep in business and
Yeah.
maybe eventually get out of the bankruptcy. And they
Right.
make a deal with the creditors to pay off their debts over time. And usually one of the rules is the creditors have to agree. What happens if they don't agree? When you switch it to Chapter 7, you just divide everything up and maybe not everybody gets paid.
Do you want to get paid or not? Basically,
You want
the
to get paid,
threat.
just wait over time. That's
Yeah.
essentially what Chapter 11. Now, Chapter 11, in my experience, comes into play fairly often when there's some kind of a lawsuit and there's a whole bunch of money the company owes. It
Yeah.
can be because of bad business. It can be because of a downturn in the economy. Eastern Airlines in the 1970s got into a fight with their unions and they eventually went out of business. Right now, Yellow Truck in Tennessee is filing bankruptcy because they've got overextended and they're also having some difficulties with their union members, and that's a whole thing.
Mhm.
Famously, also where we live in Chattanooga, there was the famous case of Crystal Restaurants filing bankruptcy because they basically were accused of not paying overtime the way they were supposed to, and in order to discharge that and get and to read and to not pay all that at once and basically go out of business, they filed bankruptcy and reorganized. They're still in business today. You and I can go get a Crystal, but they basically went through a Chapter 11 back in the 90s. So that's essentially how Chapter 11 was. The last one is a Chapter 13. Chapter 13 is basically when an individual does the same thing. The
Mhm.
individual makes a deal with the creditors and says, don't make me sell everything, but if you guys will agree to it, here's how I will pay you off over the next 3 years. And under certain rules can be expanded to 5 years. If the creditors agree to that under the bankruptcy rules, then they get paid at least something. And the debtor, the guy who owes the money, the man or woman who owes the money, gets a discharge.
Mhm.
And you also get the protection if you file bankruptcy that somebody new cannot sue you except to collect the money through bankruptcy. So all the lawsuits and everything have to be filed in the bankruptcy court. That's
I had
another important part of any of these kind of bankruptcies.
I had a friend of mine explain it to me like basically those three things are different umbrellas. If it's under the umbrella, you'll find. If it's outside the umbrella, it's going to get wet, gone, sold, or negotiated up or down one way or the other. So
Yeah,
it
that's a,
depends on
that's a
what the umbrella is.
that's a
Yeah.
good way of understanding it. And the important things that happen when you file a bankruptcy, something called an automatic stay. The creditors can't keep trying to collect from you except to go through the bankruptcy court. Any debts that you have that already existed have to be listed with the bankruptcy court, and everybody has to deal with the bankruptcy court. At some point in that process, if you take out a new debt, that doesn't fall under the bankruptcy, and that creditor can try to collect. But those are complicated
Yeah.
rules. The other thing that can happen, and this is what's going to come up in a couple of stories we're going to tell today, is well, what happens if you're filing bankruptcy and one of your assets, and I'm saying assets maybe with quotation marks around it, is that you are trying to sue somebody to get some money.
Hmm.
That lawsuit could turn into enough money that you didn't have to file bankruptcy. So does that lawsuit end up getting litigated separately, or does it end up getting litigated in your bankruptcy case? And the answer is that sometimes it can go either way, but there's some interesting cases, some very interesting cases we're going to talk about in a little bit. So let's talk very quickly about a couple of famous old cases, and then we'll get to the modern era and a very interesting story or two.
Okay.
So remember that one of the early questions is the founding fathers were dealing with British common law, and British common law said bankruptcy is businesses. Private individuals, that's insolvency. Does the federal government even have the power to regulate a bankruptcy of a private individual? The answer was yes. Bankruptcy was read to be broad enough to cover, by the 1800s, most business people and banks and creditors understood that bankruptcy law had now developed and matured enough that it could also include individual creditors, individual business people who were not incorporated, a farm, an investor, anything like that. So it got read to be broad. So
Right.
in the case of Sturgis versus Crown and Shield, that one of the issues that came up was uh, whether New York State could have its own bankruptcy laws, or is that exclusively the power of the federal government? And if the federal government has the power to cover this whole area, what could be fall under bankruptcy? And could a state, this is another issue, could a state pass a law that basically changes the rules so that somebody's contract to get paid money now doesn't matter anymore because of these new bankruptcy laws? And so there's something we'll get to later on in a future podcast about the impairment of contracts clause in the Constitution. And what is that essentially? It means that the government in the United States cannot pass a law impairing the right of human beings, Americans, to contract with each other. You
Okay.
write a contract, you make a deal, and the government can't pass laws making that illegal. Basically, it's protecting sort of the idea of a free right to property and a free right to engage in trade in the United States. It's one of the reasons why it would be hard under the Constitution for us to truly become a socialist nation if you follow the Constitution's rules, that we have the right guaranteed in the Constitution to contract. But what if the government passes a rule today that says you can't do it a certain way and you enter into a contract next year? Well, maybe that law can apply to a new contract because you're entering into the contract under the current rules and
Under
you're
the current stuff, yeah.
under current rules. So these are the kind of issues that the Supreme Court first discussed in 1819, and they end up saying it's okay for New York to have its own bankruptcy laws as long as they don't conflict with federal law. And if it's a federal bankruptcy case, then it is superior. It rules. It takes over. And that if a state passes a law uh, that affects an old contract, that's not valid. But if it's a new law, but if it's a new contract passed after a state law, that's okay because when you enter in that contract, you know what the state law is. So that's that basic case. So states can have their own bankruptcy rules if they want to, but the federal government, if they pass their rules, can be supreme. All right, next big case. And this one's kind of interesting because of who was involved in it. So in Ogden versus Sanders, there was a contract between Sanders living in Kentucky and Ogden living in Louisiana, and Ogden signed over his note that he said, this guy owes me money and he's not paying. And then there's a business called factoring, and what that essentially is if you're a bank or a merchant house, it's what Scrooge did in the Christmas Carol book, was factoring. I will go to you, Clinton. You've got a business. Let's say you've got a bill that you've been sending to a customer and they're not paying. Clinton, you're owed $2,000. Are
Yep.
they paying you?
Nope. I know where this is going.
I'll give you $800 for that note.
Yeah, I'll give you money now up front. I'll take on the responsibility of collecting it
Right.
because I know when I collect it, I can go then, and if I want to, I can settle it with them for 1,500 or whatever and make money.
That's right. Or get a court to make them pay the whole thing. I get $2,000.
Yeah, one way or the other, I'm making money.
All right. So this is essentially what happened here. So it ends up being this New York bank that's enforcing a note between a Louisiana citizen and a Kentucky citizen, and the debtor, the one who owed the money, actually then turns around and says, well, under the New York bankruptcy laws, I don't have to pay for a certain reason. So the question in the case ends up becoming whether or not a state bankruptcy law can regulate the debtor-creditor relationship between people in different states, or is that only the federal government? And the Supreme Court gets involved eventually. Saunders was represented by Daniel Webster. Daniel Webster is one of the famous great triumvirate, along with John C. Calhoun and Henry Clay. Daniel Webster ended up arguing before the Supreme Court in this case and ended up winning. Daniel Webster, just if you guys are interested, I'm not going to go into his whole history. We'll talk about him some more later. We've talked about him before, but let me just give this quick thing.
Okay.
He served 2 different terms in the House of Representatives, 2 different terms in the Senate, 2 different terms as Secretary of State, and he argued over 200 cases before the Supreme Court.
Holy mackerel.
He was basically the voice of New England business interest in the Congress, in either the House or the Senate, in the time period in the early 1800s before the Civil War. The person who represented the Midwest, at the time was the Midwest, of the rural farming communities that were growing and beginning to become more business friendly, but were not pro-slavery, was a guy named Henry Clay. Guess who argued for Ogden in this case? Mr. Henry Clay. The other third member of the Great Triumvirate was John C. Calhoun, who represented basically the South, the slavery interests, the agricultural interests. They were considered the great triumvirate. They were the great orators, the great arguers in the Congress before the Civil War. And basically, when they all retired, was basically about the time the Civil War came around. We stopped trying to talk to each other and ended up shooting at each other. So basically, the holding of this case is that states can only pass laws affecting contracts in the future, and that states cannot regulate the debts or creditor relationship and basically have bankruptcy laws that affect people outside of their state. So that's one of the big lessons learned there.
Okay, I'm with you. Well, kinda.
Yeah,
I'm waiting to see what 78 brings me.
we're almost there. So
Yeah.
basically what ends up happening is the bankruptcy code is developed to be uniform around the United States. That's what the Constitution says. But can there be different exemptions? So, have you ever heard of the Florida homestead exemption?
No, but I bet when you start explaining it to me, I'll remember.
It'll make sense. So here's
Yeah.
how it works. The bankruptcy code basically says, here's the basic rules for everybody. But if you're going to have to go into Chapter 7 and give up all your crap, you sell off everything, there's certain things that are exempt. And you can either go by this federal list of things that are exempt, which is a certain percentage of your property, of your home, your clothes, your tools of trade. Like they wouldn't make you give up your computer. They wouldn't make a carpenter give up his saw and hammer and nails and nail gun and everything. So there's this short list. And then different states are allowed to say, hey, in our debtor creditor rules, if you go broke and somebody collects from you and is able to enforce a judgment against you and gather all your stuff, they cannot get a lien against things like a certain portion of your home, your clothes, your family Bible, your tools of trade. There's a list in each state. Florida very famously has something called their homestead exemption, the 100% value of your primary residence. So what does that allow people to do? Well, if I'm kind of rich, but I'm going broke, I've had big money, but I'm going to go bankrupt, I go down to Florida and I buy a $5 million house down the road from Donald Trump. And then I declare bankruptcy. And the one thing they can't touch is my $5 million house I just spent all that money on in Florida. As opposed to other states where the homestead exemptions still things like $20,000 or $30,000
Capped out.
or
Yeah.
yeah. And the point is there's different rules for each state. And so one of the cases that ends up coming to the Supreme Court in 1902 is the case of Hanover National Bank versus Moises. All right. And again, this is another example of a creditor in Mississippi sold his note to a New York bank. Then the guy who owed the money in Mississippi, the debtor, moved from Mississippi to Chattanooga, Tennessee.
Yes.
And he files bankruptcy in Chattanooga. And the Supreme Court then basically is addressing the question of how much can this New York bank get from this poor guy who's losing all his money? By
So the
poor, I mean
agreement was made in Mississippi.
Mississippi.
It was sold to somebody in New York, and then they moved to Chattanooga. So we have 3 different states.
Right.
Yeah.
And that's a great way of summing it up. So the question before the court ends up becoming the guy who moved to Tennessee in part arguably because the exemptions for a debtor to keep his stuff is better in Tennessee than it was in Mississippi.
Yeah.
But he waited till he got to Tennessee to file bankruptcy. And so the Supreme Court basically, the bank argues, look, the Constitution says these rules have to be uniform across the United States. Now, each state has its own exemptions. How is that uniform? Why should this guy get to keep more of his stuff in Tennessee? We want as much stuff as possible to pay toward this note because he owes it. Because we bought it from the creditor and we are entitled to the full payment of this note. And if he uses the Tennessee exemptions, we'll get less stuff than if he uses the Mississippi exemptions or the federal exemptions. And the Supreme Court says no, as long as the law is applied uniformly in each state, it's okay for the federal government to write the bankruptcy laws to allow each state's exemption to be applied in that state. So that
in other words,
that.
each state can have their. It is fair because each state can come up with their own exemption laws. Basically,
Yep.
if we were telling Tennessee they had to live by certain rules and Mississippi didn't, That would be different. The states are coming up with their own exemptions.
States are coming up with their own exemptions, and
Yeah.
so the Supreme Court basically says we'll consider it to be uniform as long as we always say if you're in this state, these are the rules. If you're in
Yeah.
this state, these are the rules. But we can't say Clint Powell because we know he voted Democrat the last 3 times. Democrats or Republican, whatever you voted, have to pay more in tax, pay more in a bankruptcy and have less exemptions,
Well,
or that women have a different exemption, or whatever it is.
but you also can't. It seems to me you can't say Clint Powell lives in Tennessee because the debt was sold to somebody in New York. We're going to live by the New York rules now. Either you can't do that either. And that was, you know what I'm saying? Just because the debt's been sold and owned now by somebody, by a bank in New York, doesn't mean I have to play by their rules. They play by the rules of where I live.
Of where you file bankruptcy and where you live when you file bankruptcy. Yeah, that's essentially it. Okay. All right. Now we're going to get a little nerdy for a second before we get a little sexy. And the little bit of nerdy
sounds like my adolescence.
The little bit of nerdy is to understand this idea of Article 1 versus Article 3 judges and the right to a jury trial. So we talked about this a little earlier. The fact that if I file bankruptcy, if I'm the debtor in a bankruptcy, but one of the things that I own is a lawsuit. One of the things I'm doing is I'm suing because somebody hit me with a car, and I'm going to get that insurance company and that driver to pay me $200,000. Well, if they pay me, then that money comes to me, and I might be able to pay off most of my debts, or maybe not all of my debts. So if I'm in bankruptcy, under the rules of bankruptcy, either the bankruptcy trustee or the court, that's not important how that all works, but somebody takes charge of all my assets when I file bankruptcy and decides how much money all my creditors get. Well, if one of the things that I owe money on is a bunch of medical bills making me file bankruptcy, but it turns out somebody hit me in a car wreck and I might be able to collect from them, either the bankruptcy estate, everything that I own that gets turned over to the bankruptcy court, owns that lawsuit and gets to go pursue it, or maybe it's even litigated in the bankruptcy court. Now, why is that important? Let me just cover this about Article 1 versus Article 3 judges, because this is going to come up for these next couple, 3 cases. Under the Constitution, Article 3, we'll talk about in the future, talks about Congress has there shall be one Supreme Court, and Congress may appoint inferior courts, and the judges in those courts serve for life and cannot have their pay decreased while they are judges. It basically guarantees an independent judiciary in the United States. We have a separation of powers, and the judicial branch has separate control over their matters. They can't be fired except through impeachment, and they can't have their income taken away by Congress. It was established to keep them independent. The judges in bankruptcy court are not Article 3 judges. Bankruptcy courts were created separately by Congress just to be special judges to hear bankruptcy cases. And so technically they're a creation of Congress. So they're an Article 1 court, is why they're called Article 1 judges, because Article 1 covers the power of Congress.
Right.
So if Congress has the power of bankruptcies, and Congress establishes special courts to be the federal courts to hear bankruptcy cases, and they're under the rules of the set up by Congress, including the fact that the judges do not have a lifetime appointment, and that they can have their pay go up or down based on what Congress wants to do, they're not truly Article 3 judges. So if my car wreck is going to go into court, one of the options would be that if everybody says it's okay, we concede to do this, you can have it heard in the bankruptcy court, and the Article 1 judge would hear the case. But if I oppose and I said, no, I didn't really hit that person, or that person didn't really hit me, or I want more damages, or I just want to handle differently, under the 7th Amendment, we as Americans have the right to a jury trial in civil cases. So wouldn't we be able to say, no, you can't force this case into the bankruptcy court. We need to do it over in the regular federal court, or even in state court, depending on who has jurisdiction, because it's not something that can be decided by an Article 1 judge without a jury.
And basically, there's other stuff involved. We'd rather more people hear this. We'd rather take our chances with a jury because there's a bigger, deeper story here.
Yeah, and the important thing is there's 2 rights that are going to come up. In this case, the question is, do you have the right to a jury if your case is related to a bankruptcy, but it's not the actual bankruptcy debtor creditor stuff itself?
Gotcha.
if it's one of the assets of the bankruptcy. In the case of Grand Financiera SA, which is a South American company, versus Norberg, the Supreme Court in 1989 holds in this case that you're entitled to a jury trial for the related claims that would fall under common law. So in this case, one of the arguments was that the company that was going broke spent some money just before declaring bankruptcy on stuff that was basically like giving it away to friends kind of stuff. Like, we're going to buy this owner of the company a new swimming pool and then call it a company expense. Those are called, and there's tons of different examples of that.
Yeah.
I'm going to give my mom $100,000 salary for 10 days work. And then that gets that money out from under the company. And then the rest of the company can declare bankruptcy, but you can't touch that $100,000 because that was an expense by the company. If those things are clearly not in good faith, not for value, not even clearly, that's part of the fight, whether those things count as fraudulent transfers. Well, sometimes the question of fraudulent transfer is controlled by bankruptcy law, and so you have to hash all that out by the Article 1 judge in bankruptcy court. Sometimes, though, when there's international law involved or different laws that define what's a fraudulent transfer, you might have a separate cause of action that basically says a company's never allowed to do that, even if they're not going bankrupt, and that violates the value that the shareholders have, or that the
Right.
owners of the company would be
Well,
entitled to.
Well, basically, it sounds like one is just inappropriate use of funds and fraud in a company, period, based off the rules and regulations. The other are specifically just to help you deal with the bankruptcy. Right. It's
Correct.
the
And
same
again,
actions, but they could be
well,
deemed inappropriate or illegal
they
based
are
off
very
the reason.
they're very similar actions, but when you
Yeah,
get hyper technical, some fraudulent transfers, the question, is that a fraudulent transfer enough, is clearly just a plain old bankruptcy question.
that's what
But
I'm saying. Yeah.
other times it can be a separate, that sounded like a state law fraudulent transfer, and I get a jury trial for that.
Yeah. Gotcha. Yeah. Yeah. I
And
get it.
so in this case in 1989, the Supreme Court had to go with this very complicated question and go, no, this one is traditionally a civil law fraudulent transfer case, and you are entitled to a jury in any civil actions that are not core to the bankruptcy.
Mm-hmm.
All right. So if we have a separate car wreck case, a separate defamation case, a separate question over a promise made to pay a certain amount of money or whatever, those kind of fights, arguably you're entitled to a jury trial separately from the bankruptcy. Whether it's in the bankruptcy court or not is a different question. That's not decided yet.
Mm-hmm.
All right, now we're ready to tell a little story. And I'm going to be curious at what point you go, oh my gosh, that makes sense.
Well, if you're waiting on that for me on these things, man, it might be a long road.
Let's tell a little story, Clint.
I love story time. Once upon a time, Eric
Once upon a
Buchanan.
time, around the same time you and I were born, a little girl was born in Mexia, Texas.
Okay.
Her name was Vicki Lynn Hogan. Ever heard of her?
Mm-mm.
Hang on. 1984. What year did you graduate from high school?
86.
I graduated in 85. She was born she's 10 months younger than me, so she must have been either a sophomore or junior. In 1984, she dropped out of high school. So he gets a job at Jim's Crispy Fried Chicken in Mexia, Texas in 1985.
Nothing better than some Jim's fried chicken, dude. Woo.
And this pretty young girl who's about 18 years old marries the cook, Billy Wayne Smith.
Okay. Oh, Bill.
So she now is named Vicki Lynn Smith. They have a son, Daniel Wayne Smith, in 1986. 1987, Billy Wayne Smith and Vicki Lynn Smith get separated. And
good times just don't last like they used to, man. Dang it.
And Vicki Lynn Smith decides that working at the chicken frying convenience store is not going to provide for her.
I bet, due to your conversation at the beginning of this, I bet I know what field she went into.
Take a guess.
Did she go to be a dancer?
She went to be a dancer. Guess what else she did to become a dancer at the same time? What would you do to increase your?
She had probably some surgery to augment her breast.
This is going to come up in the story later on as well.
Okay.
That yes,
we're handling this in a tactful manner. Yes.
That she had breast augmentation surgery.
Yes.
Apparently, in her case, it was very successful aesthetically.
Okay.
I.e., they were attractive.
Okay. Yeah.
We're going to know that in a little bit more when we get further into this. But apparently, according to some family stories, this is around the time she started taking pain meds pretty regularly, and started even at that early time having some addiction problems to pain medications because of the pain meds she was given after having the surgery. All right. So she goes and starts working as an exotic dancer in Houston, Texas. In 1991, while working as an exotic dancer, she meets an 86-year-old man who comes to the strip club, and his name is J. Howard Marshall. Now, J. Howard Marshall is very taken with Vicki Lynn Smith, and he regularly inquires about her health and takes care of her, hires her for services. And before long, they have an
Yeah.
arrangement where she no longer works as an exotic dancer. He is paying for and supporting her. And according to family stories, he asks her to marry him several times.
Okay.
Now, she says several times in there that A, I'm still married, I need to take care of that. But that B, I don't want to just be seen as a gold digger, because
Okay.
it turns out that J. Howard Marshall, the 86-year-old man, owns 16% of Koch brothers industries, and at this point is worth about $1 billion. Now, if you're an
Back in
86
the
year old,
80s.
if you're this was in the early 90s,
I mean,
worth
early
$1
90s. Yeah.
billion in
Woo.
1991, and how does an 86-year-old billionaire spend his free time? At a strip club in Houston, where he's made friends with Vicki Lynn Smith.
Okay.
He's offering to support her. So she quits working as an exotic dancer, and she takes up modeling and acting. Based on his support, she's able to do it. And her big break comes in 1992. She's on the cover of Playboy, the March 1992 issue. She's so popular based on that appearance on the March 1992 issue. And by the way, for those of you out there that are around our age, if you ever saw it back then, it was the debutante issue. It was an issue that had famous debutantes who had later become willing to be exposed in Playboy.
Yes.
May of 1992, she's the Playboy centerfold.
Okay.
1993, she is named Playmate of the Year.
Okay.
And also in 1993, she divorces Daniel Wayne Smith, the guy who was the chicken frying husband that she hadn't been with in about 5 years. And she, in 1993, as Playmate of the Year, she gets a contract where she replaces Claudia Schiffer as the model for Guess Jeans. And she changes her first name during this process in 1993 to Anna Nicole.
I see what you did there. You did the old cultural switch. Anna Nicole Smith. Is that
This
where
is
we're
Anna
going?
Nicole Smith is who we're talking about. So Anna
Well,
Nicole
you
Smith
did
now.
it by you sneaky dog. You made it all right. Look at you.
So Anna Nicole Smith in
Mhm.
1993 is now starting to get picked up in modeling jobs. They're not just Playboy, but straight GQ magazine, Guess Jeans, several other major companies. And so for those of you who are a little younger than me and Clint, if you don't immediately recognize the name Anna Nicole Smith, please just pause this podcast for a second, go to your local, pull out your phone, go to a computer, and look up pictures of Anna Nicole Smith. Especially look at pictures of Anna Nicole Smith in the 1990s.
Dude, she was basically I think an improved version of. She looked just like almost Marilyn Monroe a lot of times. The way her makeup and everything. She was beautiful.
I think she was compared to Marilyn Monroe and James Mansfield both, except maybe at first, maybe a little even more.
Yes.
Let's just say not as well rounded as Marilyn Monroe,
Yes.
and more in a 1990s style. She was about as hot as it got. Maybe.
Yeah, she was a very attractive young lady.
Very attractive young woman.
Yes, she was.
In 1994, she has two big events. She's just gotten divorced from her husband, who was the cook at the chicken frying place in Mexia, Texas.
Mm-hmm.
She ends up being hospitalized for the first time for mixing prescription pain meds and alcohol. So she's been taking pain meds enough that it's getting to be a problem. And she's still pretty young. She's 27. In June of that year, now that she's divorced, and now that she's had this success on her own, she agrees to marry J. Howard Marshall. the guy who's worth about $1 billion.
Right.
Family stories again say that she actually refused to get divorced earlier and marry him sooner because she wanted to have her own success before she married him, that she loved J. Howard Marshall so much that she didn't want to be seen as a gold digger. And it was only after she'd been hired by Guess Jeans and some of these other mainstream companies to really pay her significant money to be a model that she said, okay, now in good conscience, I can marry the love of my life, J. Howard Marshall, the 80. But
That
at
took
this,
care of her when she needed it back in the day.
yeah, at this point, I think he's 88 years old and worth $1 billion.
Okay. I'm with you, man.
They're married in June of 94, and Marshall dies August of 95. All right. So 1996, the legal troubles that were leading up to what does this have to do with bankruptcy, Clint? You're supposed to ask me along the way.
Hold on a second. Wait a minute, Eric. Eric, what the hell does this have to do with bankruptcy?
It's going to get interesting.
Oh, there we go.
All right. So 1995, when he passed away, Anna Nicole Smith starts telling people that he promised when they got married that he would change his will to give her one half of the estate. She also says, or at least maybe it's one half of the increase in the value of the estate while we're married. So there's two different stories that she's quoted as saying. Remember, the estate's worth $1 billion. By the time he dies, it's $1.6 billion. That's $1,600,000,000 and change is what the estate is worth. Mr. Marshall has two sons, one who's named after him, that's the third, and the other guy is a guy named E. Pierce Marshall. Well, the guy who's the third is written out of the will because he tried to help orchestrate a takeover of the Coke company, and he ends up becoming persona non grata to his dad. He's been written out of the will, but the rest of the will leaves a little money to charity, a significant amount of money to charity, and the rest of it goes to E. Pierce Marshall, who is the son of her husband, Anna Nicole Smith's husband, Mr. Marshall.
I'm with you so far.
When all of this is going on, Anna Nicole Smith ends up getting sued herself by her nanny that's been taking care of her son. And her son's, 9 or 10 years old at this point. Let's see, he was born in 86. So yeah, so he's 9 years old. And he's got a nanny. And the nanny accuses Anna Nicole Smith of sexual harassment. So this is one woman accusing another woman of sexual harassment. That case would have been interesting if it had gone to trial, but it didn't go to trial. Anna Nicole Smith is dealing with all this stuff with her husband passing away, fighting over the estate, trying to claim what she can, also working as a model, working for Guess Jeans and these other places. And she totally blows off this lawsuit from the nanny accusing her of sexual harassment. And the nanny ends up getting a default judgment. Well, what's a default judgment? Very simply, if I sue you, Clint, and I say you owe me $500,000 and you just don't even show up to court, but I can prove I gave you notice of the lawsuit, that you were properly served, and you refuse to show up in court and you refuse to defend yourself,
You win.
I can get an automatic judgment against you called a default judgment.
Yeah.
So she ends up getting, Anna Nicole Smith now has a default judgment against her worth $850,000. How do you get out of paying an $850,000 default judgment?
Bankruptcy.
That's what the subject is today, right? We're going to talk about bankruptcy.
Bam.
Anna Nicole Smith files bankruptcy where she's now living in California.
Was it 7, 11, or 13?
So I think she's filing chapter 7.
7? Yeah. Okay.
But it may have been chapter 13 that she
I'll look it up.
argued for
Keep
at
going.
first, because part of what she's arguing is, in order to, so what ends up happening, it must have been chapter 13, because she's going to argue that I can get out of the paying this by filing bankruptcy, but I want other assets brought into the court case. And she claims as an asset her claim that gets filed in the Texas probate court that she's entitled to either one half of Mr. Marshall's estate or one half of the increase in value during the time of their marriage. So either one of those claims. So she has lawyers now fighting in the Texas probate court to say that she has a right to that money. And this is important.
It's saying at chapter 11 real quick, sir.
Oh, but I guess it was her business she did it as a business thing. Right, but that means she keep operating. Okay, so pay attention. This is where it gets a little complex, and I want to make sure we all are on the same page. In Texas, the probate court is deciding who gets the money under the will. Anna Nicole Smith hires lawyers in Texas to go into the probate court, and they don't say that the will is invalid. What they say is that Anna Nicole Smith has a claim to the amount of money she was promised as basically a contract. So she's essentially a creditor
Hmm.
against the estate. She's not arguing that the estate plan is invalid.
Right.
She's saying it should have been redone. And here's the really important thing she claims. She claims that the son, her stepson,
Okay.
Pierce Marshall, had interfered with her husband's willingness to follow his agreement, and that the son had talked him out of it, and that she comes up with the claim that this is a tortuous interference with a gift or a promise.
Hmm.
That is not a claim that the will or the trust stuff that's set up for the estate is invalid. It's a claim against either the estate or, in this case, against directly the her stepson, the guy who's
Right.
actually older than her, but is technically her stepson. And so, because it's not technically a claim against the estate, she has it. She raises it in Texas as a claim, but she can't bring the Texas probate court decision out of Texas to be heard in her bankruptcy case. But she files the claim of tortuous interference also in the California bankruptcy court. So she's suing her stepson, E. Pierce Marshall, who's much older than her. He's in his 60s, for interfering in her gift of all this money under this estate. And so it's going on both in the Texas probate court and in the California bankruptcy court. So in September of 2000, the bankruptcy court in Los Angeles decides in Anna Nicole Smith's favor on this claim of tortuous interference with the promised gift to the tune of $449
Million.
million.
Yeah.
All right.
I
Now,
knew
what
she had won the case. Once you started bringing this up, I remember she won the
she
case.
wins at this point,
This, yeah, it
but it
keeps
gets
going.
better.
Yeah.
All right. So that happens in July of 2000. But in July of 2001, the Texas probate court enters their decision as an official Texas state decision
Hmm.
that says we don't find any grounds for any valid claim by Anna Nicole Smith over any asset of this estate, and we don't recognize this claim directly against the stepson for the tortuous interference. And not only does she get zero from the estate, but she owes her stepson, E. Pierce Marshall, $1 million in legal expenses. So Anna Nicole Smith appeals the claim from the Texas court by claiming that the bankruptcy court had jurisdiction, and that case ends up going to federal court in California. And the Ninth Circuit eventually in 2004 says that the federal court could not overrule the probate decision because the federal court doesn't have jurisdiction over probate cases. And now the case goes to the Supreme Court, and it's called Marshall versus Marshall because it's basically Anna Nicole Smith's legal name is Anna Nicole. It's actually Vicky Lynn Smith Marshall.
Marshall.
When she got married to Mr. Marshall, that became her legal name. So the case is Marshall versus Marshall. And the Supreme Court enters this very interesting decision. It's a unanimous decision written by Ruth Bader Ginsburg. And this is one of the key cases about bankruptcy and federal jurisdiction that's going to this sets a new standard, at least until her next case gets up there. And then it gets complicated again. But here's the new standard. Federal courts, under the principles of federalism and the Constitution, everything we've talked about so far, one of the things they do not have authority over is probate matters. There's nothing in Article 1 or Article 3 of the Constitution that gives the federal government the power to regulate probate matters. When you die, that's a state matter. That matters in your state. Where did you write the will? Where's your property located?
Yeah. Yeah.
And so from the very beginning, the founding fathers has basically said probate matters is a great example of one of those issues that states should have sole authority over and the federal government should never get involved in.
Okay.
Now, remember, though, what was Anna Nicole Smith's claim against her stepson, Mr. Marshall?
It was that he interfered. It wasn't. It was a claim against that she was owed money because he
It wasn't.
interfered,
It
not that it
wasn't
was
right. It
illegal.
wasn't
Yeah,
a claim that she was owed
right,
money under the terms of the estate. It was that he interfered with the promise of her husband to change his estate.
right. Yeah,
Tortious interference with a gift of this magnitude. And so the Supreme Court actually rules in her favor and makes this very technical ruling. A federal court cannot overturn a state court ruling and get involved in a state court ruling on the probate of an estate, whether the will is valid, whether the will is complete, whether there is anything that was done technically wrong with the will. However, and this was a push from the White House, even filed a had the took the side and filed took the side of Anna Nicole Smith and argued for greater federal jurisdiction. And this was the George W. Bush era, and they were arguing that federal courts should be able to handle state lawsuits that are not probate matters, but this tortuous interference with a prospective gift is perfectly appropriate to be handled in federal court as something that's ancillary to the bankruptcy matter. And so the Supreme Court says, yeah, actually, yes, federal courts, if there's proper jurisdiction, and that's a whole separate thing, but basically for a case to get to federal court, you either have to have it related to a federal case or there has to be diversity of people from different states. If you can get it in federal court, can federal courts hear something that's related to but not core to a probate matter? And the Supreme Court says yes, this claim for torturous interference could survive. But they remand it back to follow the new rules that they've outlined of how it can't overlap with the probate matter. That comes out in May of 2006. June of 2006, Mr. Marshall dies. That's how old he was. He's now so Anna Nicole Smith has now lost her husband and her stepson that she's been suing. Her widow takes over. And a couple months later, this gets interesting. Anna Nicole Smith has a daughter, Danny Lynn Hope Marshall. Now, Danny Lynn Hope Marshall, the daughter that's born in 2006, by the way, is still alive, and she's 16, about to turn 17. In 2007, Anna Nicole Smith dies of an overdose.
yep.
All right. So now the lawsuit is fought between Anna Nicole Smith's stepson's widow versus Anna
Her
Nicole
daughter.
Smith's son and daughter.
Right.
But the son then ends up dying of an overdose. And so now it's just the daughter. Guess what else there's a fight over with the daughter?
Custody.
Paternity.
Yeah.
Whose baby is it?
Yeah.
And so Anna Nicole Smith, there's so many details in here. I just don't want to miss any of the good ones. The lawsuit gets changed to Stern versus Marshall because the first person to take custody of Anna Nicole Smith's daughter is Anna Nicole Smith's boyfriend. Anna Nicole Smith's live-in boyfriend, who claims that he's the dad, is a guy named Howard K. Stern. He is not Howard Stern, the radio personality.
Right.
Who is he? He's her lawyer.
There we go.
So when all this is going on, Anna Nicole Smith starts sleeping with and then becomes the boyfriend of her lawyer who's helping her in this whole fight. So now the lawyer who's been doing a bunch of the litigation in this case is now stepping in as the parent with the stepfather with custody of the daughter to claim
Representing
the right,
her
represent
to
all
keep
the
the claim
claims
moving forward.
to keep the claim moving forward.
All right. I'm with you, man.
All right. So now until Anna Nicole Smith had told somebody else when she was still alive, right before he died, that she had another boyfriend that was like a personal trainer.
Are we about to have a Jerry Springer moment where they do a DNA test?
Yep, absolutely.
Yeah,
so she claims he's the dad.
Yeah.
And she kind of does it sort of publicly. So there's some doubt in people's minds that it's not really Mr. Stern who's the dad. And the guy who she accuses is able to prove that he's had a vasectomy for years. So he can't be the dad. But then a guy named Mr. Birchland, who's a photographer that had been taking photo shoots of Anna Nicole Smith recently, at the same time that she was living with and sleeping with her lawyer, J. Howard Stern, Mr. Birchland suggests that we might need a paternity test to find out whose baby it is. And it turns out he's the daddy.
Of course,
And
why
if you
wouldn't
go
it be? Yeah.
today, you can Google daughter of Anna Nicole Smith, and she's actually Anna Nicole. She is Danny Lynn Hope Marshall Birchland because she's now taking his name, and he's raised her. He eventually got custody. Uh, but so there's this whole paternity fight about who's going to take the case on. Meanwhile, the Supreme Court had remanded it back down to the California courts, and what ends up happening is that the Ninth Circuit ruled that Anna Nicole Smith did now. So remember, first the bankruptcy court said she got 449 million.
Right.
The district court, when it weighed the two, said she got 88 million. And then the Supreme Court said, no, no, throw all that out. You got to make sure you're separating the the claim of tortuous interference from the claim of probate,
Right.
and now remanded back down. So the federal court does have jurisdiction if it's a state law claim. However, as it gets remanded back down, it goes back to the bankruptcy court.
Now, the bankruptcy court in California,
The bankruptcy court in
right?
California,
Not the probate court, right?
and that gets appealed, and that ruling of gets put back in place of 449 million. That gets appealed to the Ninth Circuit. The Ninth Circuit said the bankruptcy court got it wrong because this would they have to give deference to the Texas probate decision. The Supreme Court takes the case. And the Supreme Court, in the case of Stern versus Marshall in 2011, issues, after all this history of this salacious stuff, the very clear, interesting rule from that now a bankruptcy rule that really matters is, remember I told you we talked about the case of in 1978 that if you have a separate claim in bankruptcy that's a civil case where you would have the right to a jury, they can't take that right away because you're in a bankruptcy. You
Right.
have the right to a jury. Well, now what ultimately happens is the attorneys for the family of the stepson, Mr. Marshall, whose wife is now basically the natural son of Anna Marie Smith's, of the guy, the billionaire who died.
His son's widow.
His daughter-in-law
Right.
is now pursuing the case, and her lawyers now make the argument, or have been making the argument, but it just never got brought to the Supreme Court along the way. The original ruling of 440 something million dollars that was affirmed, that was modified and then affirmed again and now modified again, that never should have been put down in the first place. And Anna Nicole Smith should have gotten nothing, because that claim not only was not a Texas probate action, but it was also a civil case that we had the right to an Article 3 judge. And we never, because we always objected to it being heard in the California bankruptcy case and always said it should have been held in Texas, part of that argument that we really didn't say out loud, but we kind of meant, or maybe they did raise it along the way, but it wasn't clear at first because it doesn't really get considered till this final Supreme Court case, is if you're going to bring a common law claim under federal law that a federal judge needs
We
to
get a
hear,
jury.
not just we get a jury, we get an Article 3 judge this
Right.
time. So we already
Yeah.
had the we get a jury case.
Yeah.
The new rule in the 2011 Supreme Court case of Stern versus Marshall is that if you have a common law claim that is a claim outside of the core aspects of bankruptcy, then you can automatically get it out from the bankruptcy and have it heard in regular federal court because you have the right to an Article 3 judge.
I'm with you.
And because that procedure had been screwed up the whole way through and they never should have done that, the original grant of 400 something million is thrown out. The subsequent modification of it to 80 something million is thrown
They
out.
started over, basically.
Basically they said they lost.
It's over. Oh, okay.
So now the only judgment that's left standing is the Texas probate court.
Yeah.
So they basically say that case never should have been brought in California in the first place. It never should have been part of the bankruptcy court. And if they wanted, and if they didn't have it as part of the bankruptcy court, they couldn't file it separately in California, arguably, because the claim was the Texas claim that she had, and the Texas court had ruled on that. And so the Supreme Court said basically there was no federal judgment that should be given deference, and the federal court decisions all go away. So the rule to take away now from these two cases of 1978 and 2011 is that even though cases can be brought into bankruptcy court, If you agree to that, that's okay. But if you want to have a jury trial, you have the right to a jury trial. If you want to have it taken out so you can have an Article 3 judge, you have the right to have it taken out for an Article 3 judge. But there has to be jurisdiction in the federal court for the case if it's separate from the bankruptcy in order for the Article 3 judge to hear it.
Mm-hmm.
That's where it gets really confusing. One of the interesting things is Stern versus Marshall, and I'll wrap it up with this, is the court compared this to the case of Jarndyce versus Jarndyce. And what was that? Well, there's an old Charles Dickens book, the same guy that wrote, got two mentions of Charles Dickens today because we talked about
Yeah.
Christmas Carol earlier.
Yep.
Another book he wrote was called Bleak House. And in Bleak House, one of the events that works its way through the story is that a family estate is being fought over very similar to this in a case that ends up lasting close to 100 years. And what ends up happening is this large estate is fought over for so long that the original heirs have died for 2 generations, and they've never gotten a penny, and the lawyers are just eating up the assets of the estate, fighting with each other for decade after decade after decade. And that's basically the Supreme Court says Anna Nicole Smith's claim against her husband and all these other intertwined claims that all fall in here is basically this Jarndyce versus Jarndyce. By the time the final decisions are put down that there's nothing left that's being allowed to appeal, it's like 2014, and the original claim was filed in 1996.
And the attorneys made a lot of money.
Well, unless they did it on contingency. I don't know who did it on contingency, who
Well,
did. So if you want to learn more, go Google Anna Nicole Smith and take a look at the pictures of her March and May
but
Playboy appearances of 1992 and 1993 Playmate of the Year, or look at her old Guess ads.
well, and to me though, it's a very tragic story. I mean, she dies of an overdose in 2007. She was still relatively, young, and then there's kids and stuff left behind there. And then I would have
Only
never,
one kid because her
yeah,
son died too. So
yeah,
yeah, and the
I
daughter has
would have
been raised
never
by the
thought that she would
photographer.
have. I would have never thought she would have been tied to bankruptcy Supreme Court decisions. So you did it, sir. You brought the goods today. You made it salacious and salacious and all the deliciouses, and you made it about something very entertaining, and you kept
So who would
everybody's
have thought
attention.
the little girl that dropped out of high school to go work in a fried chicken restaurant would have had not one but two
Too.
hugely important federal jurisdiction and bankruptcy rule cases, basically based on her
I
claims.
can tell you right now, the luckiest dude in this story is the chicken fried guy, the cook that was like, I avoided all that drama. Thank goodness. I was woo. I'm good.
Yeah.
All right. That's good stuff, man. This will be out on the podcast platforms later today. So I appreciate it. Now you're off a little bit for the next couple weeks, so everybody will
Well,
revisit some stuff. I'm going to cut some of these things up and put them out, but you're getting ready to take a pretty lengthy road trip, and I wish you some safe travels.
well, thank you, Clint. I appreciate that, and
Yep,
we'll see you soon.
absolutely. Bye, everybody.